I will now call the next case on today's docket, this morning's docket, State of Kansas versus Rico Barnes, case number 127097. And when you're ready, counsel, you may approach.
May it please the court, Sean Randall of the Appellate Defender's Office on behalf of Rico Barnes. Your honors, may I please request 3 minutes for rebuttal?
Yes, thank you.
Thank you. At the risk of oversimplifying this case, I believe this court has to answer two distinct issues and questions today. One, did the officers have probable cause to seize the alleged marijuana blunt from Mr. Barnes' car? And two, was the alleged consent he gave the officers to search his person clear, unequivocal, and voluntary? And was it free from any coercion? I'm prepared to address both of these issues, and we'll do them in whichever order the court prefers, but I believe since a ruling in my favor on the first issue of probable cause would make perhaps the second issue unnecessary, that's where I'll begin. Because this is a Fourth Amendment case and it's a fact-specific inquiry, I do think it's important to at least summarize the facts of the case. According to the officers, the officer who approached Mr. Barnes' vehicle from the passenger side is the one who recognized the alleged marijuana blunt on the passenger seat and told the officer at Mr. Barnes' driver's side window what he saw. It was that officer then pointed at the alleged blunt, told Mr. Barnes to hand it over, and that officer testified repeatedly that he could not tell what the substance inside the cigar wrapper was, and that he had to touch it and smell it to determine that it was allegedly marijuana. And I continue to say allegedly marijuana because we still don't know what was inside that. He was never charged with marijuana. He was never found guilty with marijuana. The state never bothered to send it off to the lab to confirm that it was marijuana. So to this day, we still don't know what was inside that. I can say that Mr. Barnes denied that it was in fact marijuana, but that's neither here nor there. In the Court of Appeals opinion, it seemed to implicitly conclude that the officer who actually retrieved it, the officer at the driver's side window, that the plain view exception would not save the warrant requirement for that search. But conversely, it did seem to conclude that the plain view exception to the warrant requirement would apply to the officer at Mr. Barnes' passenger window. According to the Court of Appeals, that officer had a closer view of the suspected blunt, and he believed it was a blunt based on his training and experience. And while I acknowledge that probable cause does not require certainty, it does require a fair probability that the vehicle or thing is evidence of a crime, and it cannot just be a hunch. Here, the officers had nothing more than a hunch. They saw a brownish, not green like the Graham case that was cited in the Court of Appeals opinion, substance inside a cigar wrapper. Neither officer could say it was actually marijuana, and they both acknowledged repeatedly that it could very well be a legal substance. None of the officers testified about anything distinctive about the alleged wrapper that made it look more or less like a...
Let me just interrupt you real quick. Okay, so let's say that this exact same thing happened, except instead of this brown wrapped, whatever it is, okay, that it was a baggie with baby powder, what turned out to be baby powder, okay? But, there was, a baggie and it was kind of rolled up or whatever, I don't know, and it had baby powder in it. I mean, does it matter whether or not it actually turns out to be illegal? Because probable cause is, is there, I defined it here somewhere, but it's, whether or not you have a reason to believe that it is an illegal substance.
Right. And so I'll go based on your hypothetical that you talked about regarding the baggie of
So it doesn't matter what it ended up being. The question is, was there reason to believe that it could be a marijuana blunt?
I believe that. I believe that is, yes, that is the question. But I think what the important analysis here in using again that baby powder analogy is that there has to be a description of what the officer saw, that those specific articulable facts that the officer saw that then applied through the lens of his training and experience can lead him to that reasonable conclusion.
A video. I watched the video. I saw it.
Yes. Okay. I believe
objective facts.
And I believe that video was included in the, at the hearing in the motion to suppress. But what was testified to was not, this blunt appeared to be hand rolled as opposed to machine rolled. There wasn't testimony that he smelled marijuana. There was no testimony that he was driving erratically.
Required under plain view. Plain view is kind of implicitly eyes.
Yeah, yes, the plain view exception does requires probable cause that the item be an instrumentality of a crime or illegal in some way. And what I'm trying to say is that just saying that based on my training and experience, I believe this to be marijuana misses the point of having to have specific articulable facts to support that conclusion. Here they have, I saw this based on my training and experience, I believed it was marijuana. When pressed, why did you think it was marijuana? Well, I saw something that looked like marijuana on the outside. The only thing that was then testified after that was, well, what did it look like? It was a brownish substance, and there was nothing else that was included. And I think that's the problem here, is that if you're going to establish that I used my training, or an officer is going to establish that he used his training and experience to determine that this was most likely or probably the instrumentality of a crime, then there has to be some specific articulable facts testified to and admitted as evidence to support that conclusion.
Even when a video is introduced?
Well, I think that I guess I don't understand what we saw in the video that's different than again, the idea that I saw this, it was brown, or a brown substance inside a cigar wrapper. I don't think that establishes the necessary facts for the probable cause determination that the officer made.
And there was no other indicia that you mentioned. There was, and I appreciate this is plain view, but typically these stops include, well, there was an odor of marijuana emanating from the car as soon as I walked up, something like that, or when the window was rolled. I appreciate the window was halfway rolled down anyway, but there was no other testimony other than I saw what I believe to be a blunt or a brown something containing marijuana. That was
that's my memory of the facts. I mean, I can say there was explicitly asked, did you smell anything? No, we did not smell anything.
Okay.
At that point, because what they could smell was cigarette smoke, because he is smoking inside a car with the windows up. Then after he exited the car and that second officer went around, he said, now that there's no smoke in the car, you can clearly smell it.
I don't believe he indicated that he could smell until he entered into the car to begin his vehicle search. I think that's when he indicated that he could then smell it. But that's obviously, that would be
Afterward, right?
after the what I'm alleging obviously was an unconstitutional and unreasonable seizure. He was pulled over for an unilluminated tag light. I mean, so we don't have this erratic driving that would potentially support, okay, well, he's under the influence of a controlled substance. He denied that it was a controlled substance. The officer, the only one who, again, the Court of Appeals seemed to say, okay, well, he was closer, and he said he saw marijuana every day for 6 years, while he was on the force. Again, I'm not saying, I think it's important to try and highlight what I'm trying to say is that I acknowledge that it doesn't have to be a certainty. And I acknowledge that training and experience can be used by officers, but that training and experience still has to be based on specific articulable facts that would give rise to that conclusion. And what I'm saying here is that there was no testimony, there was no evidence of these specific articulable facts. And I'm more than happy to continue engaging in that analysis, but I think we do also need to discuss the consent issue that took place after he was ordered out of the car and brought back. And I know that this court is well aware that, there's been multiple cases that have discussed, 6 or 7 factors that we're supposed to conclude as to determine whether or not this was voluntary and things along those lines. But those factors are all used in allegedly voluntary contexts to determine whether it was truly voluntary. Here, he was detained. He was demanded out of his vehicle. He was brought back to the officer's car. They testified specifically, if he had asked to leave, he would not have been free to leave. He was detained. And I don't see how we could conclude that a reasonable person who's not free to leave is simultaneously free to say, no, you can't search me. The idea of being detained and in custody and not free to leave is inherently coercive. And so because it's inherently coercive, it does not satisfy that free and voluntary waiver or consent that is necessary.
Was there evidence suggesting that the defendant understood that fact as well?
I
That
understood what fact?
That they were detained and not free to leave.
I don't know if it was explicit, but I think, but we have to, I think we have to obviously, again,
Context.
look at those factors. He was, again, demanded to exit his vehicle, walked back to the officer's vehicle. One officer stands behind him, one officer stands in front of him. And then they ask, obviously, can we search? And I'm not going to, I'll stand on the argument that I raised in my brief about what questions were asked and the scope that he was consenting to. I do think it's important, the fact that the officer specifically asked about whether he has weapons, didn't wait or get a response from Mr. Barnes, and immediately then followed up, do you mind if I search you? I don't think it's unreasonable to assume that a person who is first asked about weapons, who's then asked to search, is consenting to a pat-down search for weapons. And this clearly was not a pat-down. They opened up a zippered pocket, they reached inside the zippered pocket, and they retrieved the methamphetamine that he is, eventually charged and arrested for. I can't see how a person in the middle of the night, surrounded by two officers who have already demanded that he exit his vehicle, who is not free to leave, could reasonably feel free to deny consent to search his person or vehicle. The Court of Appeals seemed to hang their hat on the fact that the officers didn't draw their weapons and there was no confrontation. But I don't think this court has ever held, and shouldn't hold today, that just because the law enforcement officers point their guns at you, that, therefore, you're free to give whatever consent you want, and that it's not coerced.
Any other questions, colleagues? Thank you, Mr. Randall.
Thank you, Your Honor.
Mr. Chief Justice, and may it please the court, I'm Jacob Gonteski. I represent the plaintiff, the appellee, the state of Kansas. This case, as opposing counsel noted, presents two classic Fourth Amendment questions, one regarding consent and one regarding plain view, or put alternatively, probable cause. Did the officers have probable cause to seize the blunt that they saw before them just a few feet in front of their eyes? And the state posits, obviously, yes, they did. As this court is already aware, the video is in the record. And for those who have not watched it, I would urge the court to. It provides a starkly crisp and clear view that Officer Salinas had from the passenger side of the car that day. We actually have body camera from both officers. Officer Andrus on the driver's side as he's interacting with the driver, and then we have Officer Salinas on the passenger side. As they approached the vehicle, as the court was already noting, both of the windows were rolled all the way up, and the driver had just lit a cigarette. The officer who responds first over to the driver's side knocks on the window. As he does so, the window comes down and the smoke billows out. These officers acted very reasonably. The Fourth Amendment touchstone is reasonableness, and that's exactly what these two officers did. They acted reasonably, calmly, professionally the entire time. Every step along the way of this interaction that they had with this defendant was supported by the relevant legal authority that allowed them to pursue the investigation that they had launched into within a minute of their stop of this driver.
Does the video evidence help us in any way, or help the state's position?
I believe it helps the state's position to the extent that the appellant is arguing that these officers did not have specific facts, articulable facts in support of their probable cause determination.
And wouldn't that require the watcher of the video, i.e. all of us potentially, to have the same level of training and experience that the officer has?
I don't believe it requires you to have the same level of training and experience.
In other words, I'm trying to avoid collapsing into, you know it when you see it. And we are just as capable of knowing it when we see it as an officer is.
Understood, Justice Stiegel. And I think this is a question you raised years and years ago about the availability of this kind of a video. Does it turn into what can become de novo or unlimited review of a fact situation? I believe the relevance of the video in this is that it corroborates and supports the officer's observations. The officer's testimony was clear about what they observed and what they saw, and the timing of every interaction that they had and when they made the specific observations. You can actually see from Officer Andrus's video on the driver's side as he's interacting with the defendant and asking him for his driver's license and insurance information. Officer Salinas on the other side, the window has now come down a little bit on the other side, and Officer Salinas is looking in there with his flashlight, and he mouths over to Officer Andrus on the driver's side. He mouths, "It's weed." He can see it within a minute. It's within a couple of feet of his face on the passenger seat, right in front of his eyes, clear as day. And those are the specific articulable facts. To the extent that
what made it apparent in that officer's mind? I mean, if we are going to, just setting aside the video for a second, but what is the characteristic of that item that made it apparent to the officer?
He did not
as opposed to just being a consumed cigarillo.
Correct. He even testified it could have been a consumed cigarillo. It could have been a legal substance. But in his training and experience, in his years on the road and performing traffic stops, he testified he encounters marijuana almost daily. And those facts, what he observed in front of him was plain, it was readily apparent to him from the outset. And when the Court of Appeals resolved this issue, they said they recognized the district court's common sense conclusion. And that's what this boils down to. I could describe to you that I'm standing before the lectern and I see a clock in front of me, and you could accept that as true based on your experience of being in this courtroom with a clock on the lectern. And that doesn't necessarily require me to explain all of the reasons why I believe it's a clock in front of me. Now, I could, if those questions were posed to me, recount the digits that I see before me and how they're changing and counting down, and it's visible to me and so on. And I've been told it's a clock by somebody else, all these other facts that come into the circumstances of it. But when we're talking about something like a marijuana blunt, something these officers encounter almost daily, that the courts encounter almost daily, that testimony was sufficient on its face that what the officer saw a few feet in front of him in that passenger seat was a marijuana blunt. He was not certain. He was very frank about that in his testimony in the preliminary hearing and the motion to suppress. He was frank about the fact that he was not absolutely certain. He indeed recognized it could have been a legal substance, but that possibility does not mean probable cause was not present. As the court already noted, probable cause is not certainty. Probable cause is a reasonable belief that what is before him is contraband. That's what this officer had based on years of conducting stops just like this one.
In the continuum of our case.
Yes.
I know you're gonna accept this, but I'm trying to figure out analytically where you put these facts against. So we have that Dole's case, or the black box case.
Yes.
Well, it's a black box. Nobody knows what's inside the black box, and it's just a black box. But then we have the Crown Royal bag, and we've said as part of the totality of the circumstances, officer training and experience knows that a Crown Royal bag could contain drugs, or is often used in drugs. So we got a Crown Royal bag. Right. And then we've got this blunt. Where does this sit in that continuum? Is the Crown Royal bag in the middle and the blunt's more certain? See what I'm asking about? Or is the blunt and the Crown Royal bag in the same place analytically?
I would argue the blunt is farther toward probable cause than the Crown Royal bag. And I recognize the distinction between the bag and the black box. The black box was just that, a black box. And the officer thought that there could perhaps be a digital scale in there because he had seen such boxes before. In fact, it turned out to be a digital scale, but that was not probable cause. The Crown Royal bag, in officers' training and experience, they recognize Crown Royal bags often get used to hold drugs or drug proceeds and so on, or drug paraphernalia. I believe the blunt is further toward probable cause because it's readily apparent on its face. We don't have to open the box. We don't have to open the bag. We see it before us. That's what the officers testified to. Now, they did gain more information and reached that closer to that certainty level once they seized the blunt and they were able to have it before them and smell it and see the actual flakes within it. And that ramped up there closer to certainty, but they did not need to have that at the time that they seized it from the passenger seat in that.
And then the rolled, so then counsel mentioned the rolled joint, the rolled cigarette. And I guess in my mind, back in college in the 70s, it was an American flag, that was rolled up. But that's more suspicious, right? A rolled paper would be more suspicious than the cigarello.
It could be, to the extent that the rolled up paper seemingly wouldn't have a lawful purpose other than as drug paraphernalia or as a joint. Whereas there is this narrow universe in which a cigarillo is obviously a lawful substance, and that's what could be sitting on the passenger seat. So I think there's an argument that opposing counsel has made that this could have been a lawful substance. Now, the rolled up dollar bill, the rolled up paper is on its face something you can legally possess, but officers through training and experience recognize that to be what it is, which is not the way somebody normally stores their cash and so on.
It sounds to me though, like the holding that you're asking us to make, anybody that has a consumed cigarillo, or let's even say a cigarette, because I think officers and their training and experience know that is often used by PCP users to dip a cigarette and consume the drug that way. I mean, isn't the holding you're asking for simply anybody that has these consumed otherwise lawful products, just probable cause?
I don't necessarily believe possession of all of those items would lend itself to probable cause. And I do want to recognize the fact that probable cause, the standard of probable cause is not particularly high. And what the officers undertook, this intrusion into this man's constitutional rights, was particularly limited and particularly narrow and particularly efficient. When we talk about how the officers exercised themselves in this case, it was within a couple of minutes they made these observations and they asked him to hand over the joint. That intrusion into his constitutional rights was particularly limited. They didn't immediately order him out and start tearing apart the car. They didn't rip out the back seats. They didn't tear apart the trunk. They didn't cut open the spare tire. They asked him, hand me that, because it was apparent to them that it was a joint,
Well,
and they checked it. If it had been handed to them and they recognized it as only tobacco, it appears as though that would have stopped there. So the intrusion was particularly limited. And the state's not here saying that every possession of a cigarillo is going to rise to probable.
Well, on that point, as I read the record, I doubt that these officers were of a mind to go around seizing cigarillos.
I agree.
I doubt very much that's the case. I can read the record and see what happened, and it seems very clear to me that these officers, particularly the passenger side officer, was convinced that this was not a cigarillo, was not trying to do a gotcha or whatever.
Right.
He was convinced it was a marijuana blunt. The
Right.
problem here, and I think what defense counsel's capitalizing on, is we don't know why the officer thought that. And I'm just wondering, can you articulate beyond training and experience? It's like, why was this officer convinced that it was not a cigarillo and was in fact a marijuana blunt?
I believe that his explanation, besides training and experience, but he went a little bit further when he said, and when the question was posed to him on the stand, why do you believe that? He said, because I encounter it almost daily.
That's the same thing as training and experience. It seems like a simple thing. This officer, I don't think there's any reason in the record to doubt the genuineness of the testimony and even the genuineness of the training and experience. But the problem is, he never says why. He never gives the objective, neutral magistrate the factual information needed to corroborate his training and experience?
He describes it as a brown, the burnt, flaky end.
Would you agree that that's rather thin?
I agree.
If that's all there is? And is there anything else?
When, to the extent that the question was posed earlier, for instance, we're lacking an odor. And the court recognizes why, because he had freshly lit a cigarette and rolled up the windows as the officers approached. The officers talked about that being a common thing that they encounter when somebody's trying to mask another odor being in the car. So we have a lot of other, when we look at the totality of the circumstances, we don't have the question posed to this officer specifically, what about that item on the passenger seat led you to believe that it was a blunt? It was readily apparent to him, and it's as plain as day to you and I, that a clock is on the lectern before me, because we've encountered it so many times. But he wasn't when he was in the courtroom and being asked these questions, he answered it plainly because he felt as though everybody in the courtroom essentially knew what he was getting at. Everybody in this courtroom knows what I'm getting at. But there's a universe in which we could be describing this circumstance to someone who doesn't have familiarity with this courtroom. And maybe it would call on me to be more specific about why it's a clock on the lectern before me, and why it was a joint before him or a blunt before him in the passenger seat. But the Court of
Let me
Appeal.
follow up on Justice Stiegel's question, because maybe I can get to what he's asking a little bit more. So when I watched the video, it was tiny, right? It was very tiny. But like a cigarello, usually, I mean, do they have a filter?
They usually have some sort of plastic tip on them.
Right. And so was there any testimony? Can you remind me about, because it was so tiny.
Right.
But the officer didn't testify that that was one of the reasons. Because I think that that's maybe what Justice Stiegel and Justice Wall are getting at.
Right. What was not present was a package of cigarillos or other cigarillos. There was not present an odor, a cigar odor emanating from the car. There were not other indicators that what they saw before them was simply a legally possessed substance. And when he talks about training and experience, I'm not resting this case solely on training and experience, but I don't believe as though that should be diminished to being essentially meaningless. When we're talking about somebody who encounters these objects on a daily basis, he knew it when he saw it. And that's true. It's not merely a hunch when he encounters somebody in this circumstance. With what time I have remaining.
Yeah, I was going to ask you, the clock is winding down. You referred to the clock. Speak to the consent issue and the point made that he was not free to leave. I think you would agree with that once he was outside
Absolutely.
the car. Inherently makes it not a free and voluntary consent. Speak to that.
I would like to speak to that to the extent that opposing counsel brought that up, and I jotted down what he had said. When I read opposing counsel's brief, he's not looking to overturn this court's precedent. But in coming before you today, he was essentially asking you to find that consent cannot be voluntarily given whenever somebody is in custody or detained. And that would simply obviate, that would overrule decades of this court's precedent and United States Supreme Court precedent to say that an individual who is detained or in custody cannot consent.
It's
as a matter
basically
of
asking for Miranda warnings for a search.
It is.
Is that right?
It is. And this court has said in the past that's not necessary. A defendant need not be told that they do not have to consent.
Can you speak to opposing counsel? Because I also wrote this down. In watching the video, he says, he pulls him out of the car, and then he's in front of the police vehicle, and he says, "Do you have any weapons on you?" And he doesn't even wait for an answer. And then he says, "Do you mind if I search you?" And then he says, "No problem." But counsel distinguish between, if you're searching for a weapon, that's a pat down, not a full-on search.
Right.
So what would you respond to that?
We speak of it that way because we know how officers operate, which is a pat down is one thing, a search is another. But if we're talking about a reasonable person being encountered by officers here, this individual was asked not if they could pat him down. They specifically did not ask him, may we pat you down? They asked him, do you mind if I search you?
No, but it's an
And-
inference because they didn't even wait for an answer with the weapons.
True.
I mean, would a reasonable person say, oh, they're gonna look for a weapon, not like a safety pin where you would have to look in a pocket,
Right.
but it would be a pat down. That
Right.
was my only concern there.
I believe the officer's phrasing was sufficient to allow him to conduct the search because while he did ask if the man had any weapons on him, he then asked, do you mind if I search you? Not if I pat you down. And I think a reasonable person walking down the street would interpret the question posed by the officer as, may I search you? They would think what that officer is going to do is he's going to run my pockets. He's going to go through what I have on me. He's not going to just,
Then why would
Well-
he say no problem?
why would this man say no problem?
We knew he.
Well, if we
No,
watch.
that's not in the record. I'm just.
Well, it actually is in the record of the trial that eventually happened because he sat in the back of the patrol car and confessed it all out to the camera while no officer was present. He spoke of forgetting that he had the crystal in his pocket,
Oh, I didn't.
that
see
he had the ice in his pocket. He goes on and on in the in-car camera of forgetting, and he calls himself names for having forgotten that was in there, and he can't believe that he gave it up and that he allowed the officers to search him. So
Well,
I
ask
would
you
note.
One last question. So, I didn't mean to interrupt your closing remark, but I do have a question about the nexus between these two issues.
Yes.
Is there a sort of Fourth Amendment nexus between the plain view probable cause issue and then the later what we're calling a consent search issue? In other words, if one's tainted, what is the impact on the other, if any?
If one is tainted, if consent was problematic, I believe the state's case is still saved by the fact that they had probable cause to search that car. And when they did so, they later found more in the car besides the blunt. They found paraphernalia that was going to lead to his arrest. And the officers testified as much. And what was leading to his arrest was going to result in a search incident to that arrest. And they would have discovered the methamphetamine in his pocket. So if consent is problematic for this court, I believe as though the state's case is still saved by the fact that it would have been inevitable that they would have discovered the methamphetamine in his pocket.
Okay, so I would ask whether that is preserved because the district court, had an alternative holding, but that wasn't raised in the PFR. Or, there was no conditional cross petition. So I don't think that's preserved.
The state doesn't have an avenue to preserve an issue that was never ruled against it. That ruling never fell against the state. The district court did not find, I'm disregarding the inevitable discovery avenue, that the court actually found it for the state. And so all along the way, the state has maintained that this has been a lawful interaction. Now, if the state didn't have anything to conditionally
Okay,
petition,
I get it.
I'm putting it that way. I would note that when we talk about consent and the interaction that was had that day, it was clear at the outset when Officer Andrus ordered the defendant out of the car, he told him to get out of the car. He did not ask him out. He told him, you need to step out of the car. But when he stepped out of the car and he asked him if he could search him, it was a request. It was a question. He did not tell him, I'm going to search you. He did not tell him, put your hands behind your back or put your hands on the hood of the car. He asked him. And there's a distinction in how he was addressing the defendant. There were times he was ordering him to do certain things when he had lawful authority to make such an order. And when he made such a request, it was seeking consent for that search. I wish I had more time on the clock and I don't. If this court has additional questions, I'm happy to
Any
answer them.
questions, colleagues?
If I could reclaim my time from Monday. What I would do is,
I
understand.
Court was adjourned for.
I wouldn't blame you. So I would ask this court affirm the Court of Appeals ruling as well as the district court's ruling on this motion to suppress.
Thank you, Mr. Konteski.
Thank you.
Mr. Randall, you reserve 3 minutes.
I did, Your Honor, and I don't believe that I'll be probably taking most of it, but I don't want to rehash or emphasize the questions that Justice Wall and Justice Steele were asking. But again, the question was what made it apparent? And that's, again, I think what we're missing here, my colleague indicated, that when they searched there were no wrappers, there was no cigar odor, those things weren't testified. Those weren't mentioned by the officer. The officer mentioned, I saw a cigar wrapper that had a brown substance inside of it. Based on my training and experience, that's marijuana. But again, there has to be the specific articulable facts that establish that. There was a question about, well, we've got the Dole's case with the black box and we've got the Crown Royal bag, and where does this one fall in? And I would say it's obviously, I mean, no surprise, I'm going to say that it's closer to Dole's, I suppose. But I think with the Crown Royal bag, in that case, again, there was testimony by the officer, in my training and experience, I've seen other people, keep drugs inside Crown Royal bags. If the officer said I had seen that it wasn't even mentioned whether it was hand rolled versus machine rolled. It wasn't mentioned whether it appeared as.
Why is that required? In other words, I'll push back. I mean, I asked your opposing counsel similar questions, but why isn't it enough to just say, like the Crown Royal bag, in my training and experience, this looks like a marijuana blunt to me?
Because I think I would just say that the difference in those two cases was the testimony that was provided. In this case, there wasn't the.
Was the testimony really any different? Because in the Crown Royal case, I mean, a Crown Royal bag is legal. It's like a cigarello. And kind of all the officer said is what you recited. In my training experience, this can be used. And in these circumstances, I think this is holding contraband.
Well, the difference is obviously we've got a bag versus a rolled substance, but again that there was at least something saying that not only my training and experience, but the things that I observed and applied to it, and I just don't think we have the things applied to that training and experience, those specific articulable facts that rise to it here. And my colleague also mentioned that this was a very limited constitutional intrusion, and that a constitutional intrusion is a constitutional intrusion. I think this court knows that. They didn't ask him to hand it to him. He told him, hand that to me.
I'm the one who mentioned the Crown Royal bag, but if you look at that case, there was a lot of other things happening. I mean, the Crown Royal bag with training and experience in the totality of the circumstances can add to the discussion. Your case seems to me, and you're going to agree with this, is more limited because all we have is the visual observation of the item. In the Crown Royal case, we had erratic driving, we had a safe in the back. I mean, how that's interesting. But it seems like there's more circumstances to throw into the calculus in the Crown Royal case than there is in yours. What other facts besides just the observation of the blunt do you think are relevant to the totality of the circumstances?
I can at least posit some things that I think would have assisted in that totality of circumstances thing. Again, it appeared hand rolled as opposed to machine rolled. It appeared as though
you can see that from the video.
I'm sorry?
You got the video though. So you can see.
Okay. Again, an odor I think would have been obviously the most helpful, and this court's seen how often the officers indicate that there was. I understand that now we're going to say that if you're smoking a cigarette, that's indicative of criminal activity too now, but I just hesitate. I don't hesitate. I would posit that without more than I saw a brownish substance inside a cigar wrapper, that cannot be requisite to establish the probable cause without some kind of supporting evidence to bolster that.
Thank you. Any other questions? Thank you, Mr. Randall. Thank you both for your arguments this morning.